Hello guys, and welcome to another episode of my lecture. This is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. And on today's episode of Dieko Talks Law, we will be talking about the third kind of notice under the doctrine of notice, which is imputed notice. In our first class under the doctrine of notice, we talked about actual notice. Second class, we talked about constructive notice. And in this class, we will be discussing imputed notice. Also, I have discussed the 12 maxims of equity from the 1st to the 12th. If you haven't watched the video, please make sure that you do so. Now, before we go straight into the lecture, if this is your first time of coming to my channel, please make sure that you click the subscribe button and make sure that you click the notification bell so that anytime I release a video of this nature which is going to be of interest to you, you, my friend, will be one of the first set of people to watch that particular video. Also, don't forget to follow me on LinkedIn at Dieko Daniels. Now, to my lecture for today, we'll be talking about the imputed notice. Now, if a purchaser employs an agent such as a solicitor or an estate agent, any actual or constructive notice which the agent receives is imputed on the purchaser. What does that mean? If you know that you are such a busy man, you are too busy with work and all that. Let's say you're a medical doctor, and you know medical doctors are always very busy. So because you're a medical doctor, you should not own houses, buy lands, be in real estate. You can. You know that you cannot, be doing surgery, and then somebody says, Motirileko, I have seen one land like that, is in Ogun State, and then you will run all the way down to Ogun State to come and start doing inspection. And so you therefore have somebody like an agent. Do you understand? Somebody who does the whole research for you, does everything for you, and then is supposed to give you feedback. Now, the law is that where you have an agent of such sort, any notice that agent has, be it actual or constructive, any notice would be imputed on you regardless of the fact that he told you about such notice. If he sees something while doing his searches and he omitted, forgot, neglected to tell you, the law is that notice will be imputed on you regardless of the fact that he told you. Let us look at the case of Jared and Clements, where a solicitor, in investigating a title, discovered the existence of an equitable mortgage over the property, but was deceived by a forged receipt into believing that the mortgage had been discharged. The court held that the purchaser had imputed notice of the mortgage and was therefore bound by it. Now, you see what I'm talking about? He's not the one that saw the forged receipt. That's the purchaser. Let's say the purchaser here is a doctor. He is currently doing surgery. His own agent that he sent, go and help me. Do you understand? Now, the agent got there. He saw title documents, but he saw mortgage. Don't forget, in my last class, constructive notice, I told you that when you see mortgage, go and check the bank. Have they discharged this mortgage? Don't just because you see discharged or somebody gives you a receipt, you take it for granted that it has been discharged. No, you go to the bank. Sir, there is a mortgage on this title deed. Has it been discharged? Please let me check your record. In this case, instead of the person to go to the bank, the person was deceived. He was swayed by what? By a forged receipt telling him that particular mortgage has been discharged. Now, because he saw it and he saw it as a very minute thing, he did not tell his principal, that is the purchaser, that is our doctor. He didn't tell the doctor that, my oga, see what I saw when I was doing searches. I realized that, no, because he realized that it has been discharged, so he did not tell his oga. Now, something happened years down the line. They now said, let us come back. And then they saw that, that mortgage has not been discharged. Oga said, I've never seen this before in my life. This is very, very new. Where did you see this receipt? Where did you see mortgage? I didn't know. And then he came to the court and told the court, my lord, I did not know. But then my lord said, did your agent know? Yes, he knew, but he did not tell me. Sorry about that. Because the law is, the moment your agent knew, either actual or constructive, it is imputed on you. Do you understand that? And then we go to the next case of Ollivant Limited versus Alakija. The purchaser became the landlord of the tenant, having bought the property from the former landlord at a sale conducted by the sheriff under a writ of FIFA. The bailiff announced at the sale that the property was subject to 3 leases and that rent had been paid in advance. This statement was heard by the purchaser's agent, who attended the sale on his behalf and bid for him. Nevertheless, the purchaser gave notice to the tenant asking them to pay rent immediately. The purchaser brought an action claiming forfeiture of the lease and for non-payment of rent. The trial judge gave judgment in favor of the purchaser. On appeal, it was held that the purchaser is affected by notice of equity which comes to the knowledge of the agent in the course of the transaction. The court held that the respondent had notice of the tenant's equity since his agent was present at the sale and knew all the facts. Now, what are we saying here? The purchaser, our doctor, is currently where? Surgical room. And then he told his agent, please, there is an auction of property somewhere. Now, this is what the court does. Where the court realizes that somebody cannot pay debts. Are you listening? Let us say that this case was a debt case. Someone cannot pay 10 million naira debt, but the person has a property. What the court will do, through what? Through a writ of FIFA. What the court will do is that the court will order a sale of his land or his house. Are you listening? Now, the court ordered a sale, and during the sale, the sheriff made an announcement to everybody as a form of notice. If you want to buy this house, there are tenants in this house. Those tenants have 3 leases, and those 3 leases have been paid in full. Just so you know, so that when you buy it finish, you will not say there is problem or there is this. And then he shouted, as the sheriff shouted. The agent of our doctor was there. He heard it and bought it, but did not tell his principal, that is the doctor. When the doctor got to the land and said, land that I use my hard-earned money to buy, who are all these ones in my land? And then they say, new landlord, sir, we've paid the money to the former landlord, and you know, we've paid our money in full. New landlord, that's our doctor said, no, that's not my. Did you pay me? Have you seen me before? Do I know you? I don't, my dear. So yeah, pack and leave the house. And then the tenants, they were agreed. They said, no, but we've paid. And then they went to court. Then my lord said, well, your agent knew now. Didn't your agent know? The moment your agent can attest to the fact that he knew, so to say, then that notice is automatically imputed on you. Do you understand that? Let's go further. But a notice obtained by a person other than that appointed by the purchaser as his agent will not be imputed on him. That is the case of what? Bada versus the Premier Thrifty Society. There was an attempt to impute notice of an adverse interest affecting the title of a purchaser which his informant received at the previous auction sale. The court rejected this on the ground that the informant cannot be properly described as the purchaser's agent since he merely informed the purchaser of the impending sale. Now, where the purchaser does not expressly give a person a power to make sale on his behalf, which will then make him an agent, that person, even where the person has notice, will not be imputed on the purchaser. So for example, I and my friend, we were discussing, next week I'm going to be very busy, and I really want to be at this auction sale of this land at Bada. Have you heard of that land? Yes, that's my friend talking. Yes, I heard of it. I heard that they want to sell all the lands very cheap, that they want to do certain things with money and all that. Hey, how much do you think they are selling the land? Ordinarily, the land cost about 50 billion, but they want to sell it for 10 million. Can you imagine? And I will be very busy. Please, can you help me go there and verify if the information is true? Just let me know how things are going so I will know how to prepare myself. Do you understand? That's what I told my friend. And my friend who also wants to buy said, no problem, now I'll let you know. And then when he got there and he heard certain things, he then told me about those certain things. You know. Now, did I authorize him to make sales on my behalf? No. I only told him, when you get there, let me know how things are going, so I will know how to adjust myself and all that, and come down if I have to. And then he knew certain things. There were some things that he told me, there were some that he did not. And then when I made purchases at the end of the day, they said, but that your friend was there the other time now. Didn't he tell you? Whether or not he told yourself is none of our business. As far as he was there, you know, we can impute the notice on you. What did the court say? The court rejected this on the ground that the informant cannot properly be described as the purchaser's agent, since he merely informed the purchaser of the impending sale. Can you see that? He is not there to buy and sell for me. He is there to just inform me as to what is going on. Is it true? Are they really selling land of 50 million for 10 million? What is the process by which they do it? Just let me know what is going on, so I will know how to put myself in place. So if there are certain information that he knows that he decided not to tell me, that cannot be imputed on me because he's not my agent. Do you understand? And that is the what? The case of Bada versus the Premier Thrifty Society. Now, the rule emanates from the fact that a purchaser who empowers another to act on his behalf should not be allowed to deny knowledge of fact of which the agent has notice, which makes sense. You know, if your agent has notice of someone, you've already said that he should act on your behalf. Because he's acting on your behalf, whatever he knows, you know. Do you understand that? Either actual or constructive. Now, to move further, by virtue of Section 3 of the Conveyance Act of 1882, notice will only be imputed where the agent acquires knowledge whilst acting in the present transaction. In the case of ORASANMI versus Idowu, any notice acquired by him in a previous transaction is not sufficient to affect the principal. Now, if you combine Section 3 of Conveyance Act with ORASANMI and Idowu, the agent must be acting in the present transaction. You know that, you know, we have professional agents, those people who do buying and selling professionally. Do you understand? So because this agent has bought and sell land for so many people, in a previous transaction with these people, with the same person, he had notice of something. But in this new transaction, he didn't have the notice. He had the notice since, not just now. Now, would that agent, the notice that he had maybe 2 years ago in relation to this property, will he bind the principal in this present transaction? The answer is no. Do you understand that? You must, according to the case of ORASANMI and Idowu, any notice acquired by him in a previous transaction is not sufficient to what? To affect the principal. And in the last case of Kennedy and Green, the court held that no notice will be imputed where the agent is acting in deliberate fraud of the principal. So now we have had two cases where notice will not be imputed on the principal. Kennedy and Green, where you are acting in fraud of the principal, notice will not be imputed. Bada and the Premier Thrifty Society, where he is merely an informant and not an agent, whatever notice the informant has will not be imputed on the principal. And with that, we come to the end of the lecture for today. Thank you so much for watching to the end of my lecture. Please make sure that you click the subscribe button and the notification bell so that anytime I release a video which is going to be of interest to you, you'll be one of the first set of people to watch the video. Also, make sure that you share and like this video with your friends and classmates. In my next lecture, we will be discussing how to identify equitable interest. The first thing we'll be starting with would be estate contract. How to identify equitable interest, starting with estate contract. And I will see you in my next class.